Hi everyone. I think probably we should get started now. There's quite a few people who've joined. So I will hand over to Ellie to start the slideshow. But yeah, my name's Hannah Smith. I'm a solicitor at the EUSS Centre, and Ellie is a barrister who's working with us on our EU settlement scheme project. So sorry, just letting a few more people in. So Ellie, I'll hand over to you to get started.
Thank you. Okay, so today we are going to be talking about applications to the EU settlement scheme for joining family members. We're going to cover a brief overview of the EU settlement scheme, and then hopefully we'll help you to understand who can apply to the EUSS as a joining family member and what requirements they have to meet, and give you an awareness of when an applicant also needs to apply for an EU settlement scheme family permit before they come to the UK, and teach you more about the deadlines and evidence needed in support of such applications. So to begin with, we're going to have a quick overview of the EU settlement scheme. So this slide just sets out what the EU settlement scheme is. Basically, it enables EEA citizens and their family members to apply for an immigration status, either settled or pre-settled status, that will allow them to live lawfully in the UK after Brexit. The deadline for most applications was the 30th of June 2021, but the deadline is different for joining family members. We'll look at that later. So eligibility is governed by Appendix EU and Appendix EU family permits to the immigration rules. So I talked about two different immigration statuses, settled and pre-settled status. Settled status is essentially indefinite leave to enter or remain in the UK, and holders of settled status can spend up to, or have an indefinite right to enter and stay here, as that name suggests. And they can also spend up to 5 consecutive years outside of the UK without losing that right, or 4 if they're Swiss citizens. And they have the same rights to live, work, and access health and social assistance benefits as UK nationals. And they can also access community care on the same basis as UK nationals. Pre-settled status is limited leave to enter or remain in the UK. Holders of pre-settled status are granted the right to live here for a period of up to 5 years, and then they can apply for settled status after they've resided in the UK for a continuous period of 5 years. And they've got to make their application for settled status before their pre-settled status expires. People with pre-settled status have got the same rights to live, work, and access healthcare as UK nationals, and they can access community care on the same basis as UK nationals, but dependent on the outcome of litigation in a case called Pratilla and Tenace, they can't access means-tested benefits to which the right to reside test applies unless they have a separate qualifying right to reside. So who needs to apply for settled or pre-settled status? This slide sets out different categories of people who do. So the first is so-called relevant EEA citizens. And what that means in general is EEA citizens, so citizens of EEA states who were residing in the UK before 11 o'clock on the 31st of December 2020. The second group is family members of those EEA citizens, including family members with retained rights, and we'll talk about a bit about that later. They generally also need to have been residing in the UK before the 31st of December, unless they're close family members who can apply as joining family members. And that's what the bulk of this presentation is all about. So we'll talk about that some more in a minute. The third group of people are people with a derivative or Zambrano right to reside. That tends to be people whose right to reside is based on being a primary carer of somebody with an EU law right to reside in the UK. The fourth group of people are family members of qualifying British citizens. So in general, the EU settlement scheme doesn't apply to family members of British citizens, but there's an exception for people who are sometimes called Surinder Singh family members after a European court case. And that can apply where a family member has lived with a British citizen in another EU member state and then has come back to the UK. Various other conditions apply. But those family members are also covered by the EU settlement scheme. And finally, family members of relevant naturalised British citizens, which is a very long, complicated name, but basically what it means is family members of dual British EEA nationals who came to the UK and exercised free movement rights here before they got their British citizenship and kept their EEA nationality alongside their British citizenship after they got it. So those are the main groups of people who are covered by the EU settlement scheme. Sorry, bear with me a moment. Okay, so this presentation is mostly about who you can apply as a joining family member. And so this slide gives an overview of that. So joining family members are close family members of an EEA citizen whose EEA citizen family member was living in the UK before the end of the Brexit transition period, so before 11 o'clock on the 31st of December 2020. So close family members of those people can apply as a joining family member, so long as they themselves were not living in the UK before the 31st of December 2020, or if they were living in the UK before that date, they've since broken the continuity of their residence by leaving the UK for long enough or through various other ways, or they've been released from prison after the 31st of December 2020, or they're durable partners who didn't meet the definition of family member of a relevant citizen before the 31st of December 2020, but were living in the UK on another lawful basis. So I've kind of rattled through those conditions, but we're going to explain each of them in a bit more detail in the later slides. So the conditions for applying as a joining family member are as follows. Firstly, you've got to meet the definition of joining family member. Secondly, you need to meet the definition of family member of a relevant sponsor. Thirdly, you can't be resident in the UK as a visitor to make your application, although there is currently an exemption to this requirement, which we'll talk about in the later slides. And fourthly, you can't have been resident in the UK before the 31st of December 2020 unless continuity of residence was since broken, you've served a prison sentence, or in the case of durable partners, they had another lawful basis for living in the UK. So firstly, we're going to look at the definition of joining family member. Who counts as a joining family member? Well, only close family members, including durable partners, are eligible to apply to the EUSS as joining family members. This includes the spouse or civil partner of a relevant sponsor, or a relevant Swiss citizen, durable partners, children or dependent parents of a relevant sponsor, and children or dependent parents of the spouse of a relevant sponsor. Spouse or civil partner, sorry. So turning to the first of those groups, spouse or civil partner. To meet the definition of spouse or civil partner, you've got to meet the following conditions. So firstly, the marriage or civil partnership must have been contracted before 11 o'clock on the 31st of December 2020, and the marriage or civil partnership must continue to exist at the date of the application unless the spouse or civil partner is with a retained right of residence, which we'll talk about in a minute. Secondly, the couple were in a durable relationship before the 31st of December 2020, which remained durable at the 31st of December 2020, and they've since married or entered into a civil partnership, and the marriage continues to exist at the date of their application for the settlement scheme. And we're going to talk about the definition of durable partner in a moment. Spouse or civil partner of a Swiss citizen, in order to meet the definition of spouse or civil partner of a Swiss citizen, an applicant has got to be a spouse or civil partner of a relevant sponsor. Has got to be a spouse or civil partner of the Swiss citizen, applying the same definition that we've just looked at, or have entered into a marriage or civil partnership that formed after the 31st of December 2020, but before the 1st of January 2026, and the marriage or civil partnership continues to exist at the date of the application. So there are slightly different rules for spouses and civil partners of Swiss citizens, in that they can apply under this scheme, even if their marriage or civil partnership formed after the 31st of December 2020, but it needs to have been contracted before the 1st of January 2026, and it's got to continue at the date of the application to the EU settlement scheme. So, durable partner of a relevant sponsor. To meet the definition of durable partner, An applicant has got to be in a relationship that was formed and durable before the 31st of December 2020 and remains durable at the time of the EU settlement scheme application, unless they have a retained right of residence. And as I said, we're going to talk about retained rights in a moment. To show that a relationship is durable, usually you have to show that the couple have been living together in a relationship akin to marriage or civil partnership for at least 2 years. So only after that 2-year point, in general, will they be considered to meet the definition of durable partner. But there are exceptions to this. So if you can provide other significant evidence of them being in a durable partnership, then it might be possible to satisfy the condition of being a durable partner before 2 years. But in terms of providing evidence of living together in a relationship akin to marriage or civil partnership, some examples of evidence you can provide are set out on this slide. So they include, for example, bank statements or utility bills in joint names at the same address, residential mortgage or statement or tenancy agreement in joint names, official correspondence that links the couples to the same address. So those are just 3 examples of the kind of evidence that you could use. As I mentioned a moment ago, this kind of 2 years cohabitation requirement is not a strict rule. And so if you can provide other significant evidence that a couple is in a durable relationship, even though they haven't cohabited for 2 years, that should be accepted as evidence of a durable partnership. Now, the guidance from the Home Office says that one example of when this would apply is if the durable partners have got joint custody of a child and can provide evidence of this. So, for example, a birth certificate showing that they're both parents of the child, and then evidence that they're both kind of looking after the child. But it may be possible in some circumstances also to provide kind of evidence of significant joint financial commitments. So, for example, joint tax returns or evidence of joint significant investments. To apply as a durable partner as a joining family member, it's not necessary to hold a relevant document. So that's a residence permit issued under the old EEA regulations. As a durable partner, it's not necessary to hold one of those documents in order to apply as a joining family member. So it is necessary for durable partners who are not coming in as joining family members, but it's not necessary if you're a joining family member. So there are some other requirements that need to be met in order to be accepted as a spouse or civil partner. Or durable partner. So firstly, it can't be a marriage, civil partnership or durable partnership of convenience or a proxy marriage. Secondly, the validity of the marriage will depend on whether it's treated as valid according to UK domestic law. And finally, neither party must have, for the relevant period that they're relying on for their application, have had another civil partner, spouse or durable partner with immigration status in the UK or islands based on that relationship with the party. So I mentioned earlier that sometimes it's possible to have retained rights of residence, and that can apply where there's a breakdown of a family relationship, for example, because of death, divorce, domestic violence, or the EEA citizen leaving the UK. And family members who are relying on these sorts of rights are called family members who've retained the right of residence. And sometimes joining family members who are spouses, civil partners, or durable partners can retain a right of residence. So the first circumstance in which that might apply is if the EEA citizen dies or leaves the UK. And the family member of an EEA citizen who's died, so someone might retain a right of residence in this way if they're the family member of an EEA citizen who's died, provided that they, the family member who's applying to the EUSS, lived in the UK as the EEA citizen's family member for at least 1 year before the death. Or if they're the child of an EEA citizen who's died or left the UK, if the child was in education in the UK immediately before the EEA citizen died or left the UK and is still in education, or if you're a parent who's got custody of such a child. Now, in the case of joining family members, we mentioned earlier that ordinarily they are not people who will have been living in the UK before the 31st of December 2020, and their coming to join their family member in the UK. So this sort of thing might apply to them if, for example, this death or departure from the UK happens between their arrival in the UK on a family permit and their application for pre-settled status, or after they've got pre-settled status, but before they get settled status. The second kind of situation in which residence rights might be retained is where the family relationship ended through divorce or termination of the civil partnership. And this can occur where the family member resided in the UK at the time of the divorce or termination of the civil partnership, and one of the following options applies. So firstly, before initiating the divorce proceedings, the marriage or civil partnership lasted for at least 3 years, including 1 year in the UK. Or secondly, the non-EEA spouse has custody of the EEA national's child or a right of access to the minor child, and that access has got to be in the UK. Or thirdly, a continued right of residence is warranted because there are particularly difficult circumstances, such as where the spouse or other family member was a victim of domestic violence while the marriage or civil partnership subsisted. And another category of case in which you can have retained residence rights is if the family relationship breaks down as a result of domestic violence. So this can apply where a family relationship ends because of domestic violence or abuse, and the continued residence of the family member who's applying to the EUSS, their continued residence in the UK is warranted where they were a victim of domestic violence or abuse before the family relationship broke down, or another family member was a victim of domestic violence or abuse. It applies where the family relationship ends for reasons other than divorce and termination of civil partnership. So, for example, where durable partnerships end through domestic violence. And all of this, so this kind of this right is set out in paragraph E of the definition of family member who has a retained right of residence in Annex 1 to Appendix EU. So you can look at that to find out a bit more about this right. And it's really a new right under Appendix EU that didn't used to apply previously under the EEA regulations. So this is one area in which actually rights have been strengthened. So the next category of person who could apply as a joining family member is the child aged under 21 of a relevant sponsor or the spouse or civil partner of that relevant sponsor. So to meet the definition of child of a relevant sponsor for the purposes of applying as a joining family member, you've got to meet the following conditions. So firstly, the relevant family relationships must have existed before the end of the Brexit transition period. So that's before 11 o'clock on the 31st of December 2020. And they've got to continue to exist at the date of the application under the EU settlement scheme. There is an exception for this, to this, where the child was born or adopted after the 31st of December 2020. So overall, what's got to happen is that the child has got to be under the age of 21 before the 31st of December 2020 and at the date of the application. And in order to apply as the child of the spouse or civil partner of an EEA national, their parent must have been married to the EEA national before the 31st of December 2020 and must remain married to or in a civil partnership with them now. The next category of person who can apply as a joining family member is the dependent child aged 21 or over of an EEA national or of the spouse or civil partner of an EEA national. Now, to meet the definition of a dependent child who's over the age of 21 of a relevant sponsor, the following conditions have got to be met. So again, the relevant family relationships must have existed before the 31st of December 2020, and they've got to continue to exist at the date of the EU settlement scheme application. So what this means is that the child must have been under the age of 21 or dependent on their EEA national parent or their spouse or civil partner before 11 o'clock on the 31st of December, and they've got to continue to depend on them after that date. But there is, again, an exception if the child was born or adopted after the 31st of December 2020, but that's not really going to come into play for another 21 years when those children become kind of aged 21 or over and dependent on their parents. And secondly, they've got to apply, if they apply as the child of the spouse or civil partner of an EEA national, then again, the parents must have been married to the EEA national before the end of the Brexit transition period, and they've got to remain married to them at the date of the EU settlement scheme application. So we've talked about dependency. So in the case of dependent parents or children who are aged over 21, dependent means, and we're going to come on to kind of dependent parents on the next slide. Dependent means that, taking into account their financial and social conditions or health, the applicant can't meet their essential living needs in whole or in part without the financial or other material support of their relevant EEA citizen family member or their spouse or civil partner. And such support has got to be being provided to the applicant, and for the relevant period has got to have been provided to the applicant, so that's the period that's being relied on for the EU settlement scheme application. There's no need to determine the reasons for that dependence or the reasons for having recourse to that support. So just pausing for a moment, that means is that the dependent child or dependent parent, and we'll talk about them on the next slide, doesn't need to be wholly dependent on the EEA national family member. It's enough if their EEA national family member is providing them with some of what they need in order to meet their essential living needs. And they need that support. And there isn't kind of any need to show the reasons for dependence. And just as a note, some of you may have known or been aware that previously, where applications were made up before the 1st of July 2021, the kind of dependence of some joining family members, particularly parents, was assumed, but now it no longer is. So anybody who's applying as a dependent child or a dependent parent has got to provide evidence of dependency, such as bank statements, medical letters, etc., etc. I missed the slide on dependent parents, so sorry about that. But to meet the definition of dependent parent of a relevant sponsor or their spouse or civil partner, again, the relevant family relationships have got to have existed before the 31st of December 2020 and have got to continue at the date of the application. So the parent who's applying as a dependent parent of an EEA national has got to have been dependent on their EEA national child or their spouse or civil partner before the 31st of December 2020 and continue to depend on them. And if they are applying as the parent or spouse, the parent of the spouse or civil partner of an EEA national, then the child must have been married to the EEA national before 11 o'clock on the 31st of December 2020 and has got to remain married to them now. So I think, Hannah, I don't have the slide numbers here, but I think, are we handing over now?
Yes, that sounds good. So I'll start to share my screen. Sorry, just. Okay. So can you see the relevant sponsor?
I can, but I couldn't before, so I don't know if it's switched.
Okay.
Is that me for you? I think that's still me. Do you want me to?
Can you press stop share? Sorry, I don't know if you're able. Can you just
sorry.
the button?
Yeah, have done. Sorry.
Perfect. I think that should be. Is that just the slide that's viewable now, or are there 3 slides?
Yeah, 3.
Okay. Sorry, 1 second.
Yeah.
Is that better?
Yeah.
Okay.
Thank you.
So after a person has established that they meet the definition of joining family member, they also need to show that they meet the definition of the joining family member of a relevant sponsor. So generally, a relevant sponsor means an EEA citizen who has been resident in the UK for a continuous qualifying period and who has been granted settled status or pre-settled status under the EU settlement scheme. So That means someone who was living in the UK before 11 p.m. on the 31st of December 2020 and who's made a successful application to the scheme and hasn't since broken their continuity of residence. In addition to EEA citizens, it's also possible to apply as the family member of an Irish citizen or a naturalised British citizen or a person who is exempt from immigration control who also meet these continuous residence requirements, so who have been in the UK since before 31st of December 2020 and who haven't broken their continuous residence since, who would, if they made a valid application to the EUSS, have been granted settled or pre-settled status. So these are the people that can apply for the EUSS, but they aren't necessarily obliged to. So if they've chosen not to, but in the event that they did choose to apply, they would have been granted settled or pre-settled status, they can count as a relevant sponsor. And in addition to those people, you can also apply as the joining family member of a frontier worker as well. So there are a couple of exceptions to the requirement that the relevant sponsor must have been granted settled or pre-settled status. One of them is where the joining family member makes an application as someone with retained rights of residence on the basis of events which have occurred between their arrival in the UK and the date of their application. So these are the people that Ellie was describing before in terms of who has retained residence rights. And what this means is, for example, if the partner or spouse of an EEA national comes to the UK to join their family member, and then, for example, they were subjected to domestic violence and the relationship breaks down, that partner shouldn't be punished or shouldn't be ineligible to apply as a result of the fact that their abuser, for example, hasn't made a successful application for settled or pre-settled status. So they're not dependent on their abusive partner, for example's application to the scheme. And that's the same for the people who are applying as a joining family member of a relevant sponsor who has died. So one other requirement is that the relevant sponsor is still alive, except in these particular situations where you're applying as a family member of someone who's died, when that sponsor was resident in the UK as a worker or self-employed person, either for a continuous period of 2 years before their death, or if their death was the result of an accident at work or an occupational disease, regardless of how long they were in the UK. The applicant was resident with them after the specified date and immediately before their death, and since then no supervening event has occurred. So in these situations, it suffices to show that the relevant sponsor is, or for the relevant period was, in the UK for a continuous qualifying period. The third requirement is this requirement not to be in the UK as a visitor. Appendix EU states that to apply as a joining family member, you must not be in the UK as a visitor. There's one specific exception to this, and that's where the applicant is making an application as the spouse or civil partner of a relevant sponsor, and they were in a durable partnership prior to 31st of December 2020. So one of the couples that Ellie described, which is you're now married, but you're relying on being in a durable partnership prior to 31st of December, and you were permitted leave to enter to the UK to marry or form a civil partnership with your sponsor. So there's this specific form of leave for visitors in the UK where it's a condition of your entry that you're entering so that you can marry or form your civil partnership. So in that situation, if you've entered as a visitor and then you've married or formed a civil partnership, the fact that you're a visitor doesn't affect your application as a joining family member. However, quite a lot of other people are caught within this definition of visitor. So it's defined in Annex 1 to Appendix EU, and it includes EEA nationals who entered the UK after 31st of December 2020 without any other form of leave to enter or remain, and who would therefore automatically be deemed to be visitors. So this was the change following Brexit, whereby before, if an EEA national entered, there would be free movement, they're allowed to enter, they don't need a visa, etc. Now, if they come without a visa or a form of leave to enter, then they pass through the gates and they're given this 6 months leave to remain as a visitor automatically. So it's really important, if you're advising someone from outside the UK on their ability to apply as a joining family member, to make sure that they don't just come to the UK and say, I'm coming to the UK, I'll enter, and then make an application from inside. Because if they enter and are deemed to be a visitor, that is an automatic prevention from applying. To avoid doing this, they would need to apply for an EUSS Family Permit, and we talk about that in the later slides. Or they would need to have alternative form of leave to enter. There is currently in the caseworker guidance a temporary concession to this bar on visitors applying. And this is an exceptional concession which is made outside of the immigration rules. It's just contained in the guidance. And what it provides is that the requirement not to be in the UK as a visitor is disapplied where the applicant's leave as a visitor expires on or before 30th of December 2021. So that would apply to anyone who entered the UK from 1st of January to 30th of June and were granted this automatic 6 months visitor leave, and anyone who arrives after 30th of June but whose visitor leave is less than 6 months, but it's unclear exactly who that might apply to, because most often people are granted this 6 months leave. So if you previously advised people who entered the UK as a visitor, which is something that we had done on a number of occasions, where a person had just entered without leave to enter and they were a visitor, and we'd said, you're not actually eligible to apply because of this, then retrospectively it's possible to go back to them and say, actually now you could be eligible to apply because of this concession. But now that we're past 30th of June and this concession only applies where the leave expires before 30th of December 2021, then it still remains now important to assert that people need to apply for a family permit to come, or to apply from outside the UK. They can't just come and enter and get this automatic visitor status. So then moving on to the residence requirements for joining family members. As Ellie's mentioned, they must not have been resident in the UK on a basis which met the definition of family member of an EA national prior to 31st of December 2020. So this means basically anyone who would have been eligible to apply as a family member and whose deadline was 30th of June. So someone living in the UK as a spouse or dependent parent, etc., who is eligible to apply under the system of family member of an EA national. The exceptions to this are if since the time they were resident as the family member of an EA national, they've been absent from the UK for more than 6 months in any 12-month period, and they didn't return before the 31st of December 2020. So this is basically anyone who's broken their continuity of residence. So they might have been living with their spouse in the UK before December, they've gone away, they've been away for 6 months, and then they can apply to come back as a joining family member, having broken their continuity of residence. It also applies to people who served a sentence of imprisonment in the UK. And this is quite an important provision for people who've been in the UK for less than 5 years prior to their imprisonment. So periods of imprisonment of any length break continuity of residence. If a person's been in prison for 5 years, been in the UK for 5 years prior to going to prison, then they can rely on that 5-year residence to apply as an EA national when they're released from prison, and they can apply late and say, I was making a late application because I was in prison. However, if a person was in the UK for less than 5 years before they go to prison, so they haven't amassed this 5 years qualifying period, then their continuity of residence would have been broken by their sentence. And if they're released after the 31st of December, they can't restart the clock on their continuity of residence, because the definition of a continuous qualifying period is that it starts before 31st of December 2020. So for those people, they may not actually have an ability to apply to the scheme unless they can apply as a joining family member. So if they come out of prison continuity of residence been broken, for example, because they lived in the UK for 4 years before prison, they can still apply as a joining family member if they have any of the joining family members we discussed living in the UK. Then finally, this exception for Swiss citizens. So as we said, there's a slightly different system for spouse civil partners of Swiss citizens. So if they're the people that were subsequently married between January 2021 and 2026, then it doesn't matter if they were previously resident before 31st December. In the case of applicants who are children who were born or adopted after the 31st of December 2020, or who become the child of a relevant sponsor, obviously it doesn't matter if they were resident before the 31st of December. For example, if they were just living in the UK and then they're adopted subsequently, then that residence prior to their adoption isn't a bar and they're applying. But there are just these certain conditions which must be met. So either both of their parents must meet the definition of a relevant sponsor, or one of their parents must be a relevant sponsor and the other is a British citizen, so they're not a relevant sponsor, or one of their parents is a relevant sponsor who has sole or joint custody rights over them. So essentially, the child needs to be the child of a relevant sponsor. At least one of their parents must be a relevant sponsor, and that parent must also have custody rights, be that sole or joint, over the child. Where the applicant is applying as a durable partner and they're not eligible to apply as a family member of an EEA national rather than a joining family member, and the only reason that they're not eligible to apply is because they don't have a relevant document, then these joining family member provisions can be quite helpful. So say you have a durable partner of a French national who was living with that person for 3 years prior to the 31st of December. They meet these definitions of durable partner in that they've cohabited, they have joint custody of a child, etc. But the only reason they're not eligible to apply as a durable partner under the application as a family member is because they don't have a family permit. Then if they had another lawful basis for being in the UK at that time, they can apply as a joining family member. So as a joining family member, they'd still need to meet these definitions. They'd still need to provide evidence of their relationship, so of living together for 2 years, for example. But if they don't have this relevant document, so family permit, etc., if they can show they had another lawful basis for residing in the UK, they can apply to the EU settlement scheme as a joining family member. So if they had a work visa, a student visa, leave to enter or leave to remain under any other immigration rules, then this is quite a helpful way to get round that very specific requirement that durable partners need a relevant document. So we're just going to move on to talk about a few of the more practical aspects of making an application as a joining family member. Certain applicants can apply to the EUSS as a joining family member from outside the UK. So if you're from the EU, you're an EEA or Swiss national, and you've got a valid passport or identity card with a biometric chip, you can just apply directly to the scheme before you come to the UK, and you can apply online, and you don't actually need to apply for an EUSS family permit. You just go straight to Appendix EU and you make your application directly. If you're a joining family member from outside the EU, so you're not a EU, EA or Swiss citizen, or you don't have a biometric identity document, you can only apply if you already had a relevant UK document. So for example, if you've already been given a residence card, derivative residence card, family permit, etc. Otherwise, it's necessary to apply from inside the UK. And to apply from inside the UK, you must first apply for an EUSS family permit to actually allow you to travel to the UK and then make your application. So EUSS family permits, the application can be found online. We've included a link on the slides. And the requirements for applying for such a permit are set out in Appendix EU family permit. And basically, a person needs to upload evidence that they meet the definition. So the definition of joining family member, relevant sponsor, etc. And then they will be granted an EUSS Family Permit, which allows them to come to the UK and then apply to the EU settlement scheme. So there are two different specific timelines and deadlines and durations of an EUSS Family Permit, depending on when a person applies and when they are planning to arrive in the UK. If they make an application and the application is approved less than 3 months before their planned arrival date, then the permit is valid for 6 months from the date of the decision on the application. If they apply and the application is approved more than 3 months before they plan to arrive in the UK, then the validity begins from their planned arrival date rather than the date of the decision, and it'll be valid for 4 months from the date that they arrive. And when a person gets this EUSS Family Permit, they can come and go from the UK as many times as they want whilst it's valid, and they can also work and study in the UK with this permit as well. But it's important that such person must apply to the EUSS prior to the expiry of this family permit to continue residing lawfully in the UK after the 4 months or the 6 months, depending on how long it's valid. So there's no set deadline for applying to the EU settlement scheme for joining family members. They can arrive in the UK at any time. You know, they could make an application at any point in the future. They would just still need to be able to show that they met the conditions. So they had the relationship they needed to at the 31st of December 2020, and that relationship was continuing. So if an applicant arrived before the 1st of April 2021, then their deadline was the same as anyone else applying to the EU settlement scheme. It was the 30th of June 2021. If they arrive on or after the 1st of April 2021, then they have 3 months within the date of their arrival in the UK to apply. And again, if the application relates to a child born or adopted in the UK after 31st of December 2020, then they should apply within 3 months of the date that they were born or adopted. I think that should actually say the 1st of April, sorry, rather than 31st of December 2020. So another deadline, if the applicant is the spouse of or civil partner of a Swiss citizen, then they must again apply within 3 months of the date of their arrival in the UK, but they also have a hard deadline of the 1st of January 2026. So they can't arrive after that date in the same way that other family members could. If the applicant does miss this deadline, then it's still open to them to argue they have reasonable grounds for missing the deadline. We recently did another training on late applications and reasonable grounds for late applications. So whilst they might have a deadline of 3 months from the date of their arrival, if they do apply after that date, then they can still try and argue that they have reasonable grounds for missing that deadline, and it's definitely worth doing that. This 3 month deadline is also something to be wary of when they might have leave to enter or remain for 6 months under their EUSS Family Permit. So a person can come, enter, leave work for 6 months, but they still need to apply to the EUSS within 3 months of their arrival, regardless of the fact that their EUSS Family Permit might remain valid for longer than that. So this is just a checklist of things that you might need to support an application for a joining family member. As with all applications to the scheme, valid evidence of the applicant's identity and nationality, and then also evidence of their relationship to their relevant sponsor. So if it's a child or a dependent parent, they would need the birth certificate to show that they are the child or parent of that person. Marriage certificate if it's a spouse, civil partner, or if it's a child of a spouse or civil partner of a relevant sponsor, then that child would need both birth certificate and marriage certificate to show the double link between the parties. For durable partners, they'd need their evidence of cohabitation, relationship akin to marriage, so their joint finances, their joint custody of a child, etc. And And if it's a dependent child or dependent parent, then they need evidence of their dependency. So that might be bank statements, for example, which show financial transactions between the parties, or a medical letter from a doctor which says that the parent is reliant on their child for care. If the person is applying as a durable partner who was resident in the UK on another lawful basis prior to 31st of December 2020, then it would also be helpful to upload evidence that they were residing on another lawful basis. So a picture of their visa, for example, which meant they were lawfully in the UK prior to this date. And then finally, evidence of their sponsor status under the EUSS. So if it's someone who's been granted settled status or pre-settled status, then they should provide the unique application number of that application. And that in turn will prove the continuity of residence and the nationality of the person. If it's someone who didn't apply because they weren't obliged to, for example, the Irish or the naturalised British citizen, then they would need evidence of their sponsor's nationality and their residence as well. So that's the end of our overview of the applications for joining family members. I don't know if anyone has any questions or anything they'd like us to follow up on. And feel free to ask or to put them in the chat.
Hello, I'm Emma Harris.
Hi, Emma.
Yeah, I'm kind of struggling a bit with all of this, to be honest. I'm only dealing with appeals. I'm a barrister at Goldsmith Chambers.
Okay.
So I'm not having to deal with applications so much. But I'm just wondering, I mean, this may be a bit of a wider question than just for joining applicants, but I've got quite a lot of durable partners who didn't have documents before the 31st of December. Lots of them had planned to get married and things like COVID stopped them. I'm wondering, it doesn't sound like, I mean, if they had no other lawful basis to be in the UK, it doesn't sound like going abroad to make an application as a joining family member is going to help them at all. I mean, do you know if any allowances are being made for COVID reasons for not meeting requirements or for dates? Probably not.
Ellie, I don't know if you want to.
In terms of sort of failing to apply for a relevant document before the end of the transition period, I'm not sure the COVID guidance makes any allowance for that, unless Hannah disagreed. But we've been looking, Hannah and I have been talking about whether we could make a challenge in some cases to the requirement for a relevant document, and whether in some cases it might be possible to argue that it's disproportionate. So there's a provision in the withdrawal agreement that requires the UK to have an appeals process, and that says that essentially the point of that appeals process is to make sure that the decisions are proportionate. And so we think it's implicit in that decisions on applications should be proportionate, and that in some cases it might be possible to argue that it's disproportionate to require that document. It's, so far as we are aware, I mean, we were talking about this a while ago, I haven't looked for an update on the case law very recently, but so far as we're aware, that kind of argument is untested at the moment, but we're kind of thinking about whether we could run it in some cases.
Yeah, I've been kind of raising Article 8 as a new matter on appeals, but that's really helpful. Thank you.
Okay.
Yeah, I think so. This is, it's not a practical suggestion either, but I guess the other option is to would be breaking continuity of residence perhaps, and then applying to come back. So rather than saying that you'd not, sorry, I just need to think this, let me think this through and then we'll come back to that. And there's another question here. So question about partners who are not married, can they apply to? How can they prove their relationship if they are not living with their partner with PSS in the UK? So is this, can I just check, is this somebody who's never lived with their partner, they've only ever had a remote relationship, or is it someone that's since lived apart after having lived together? I think that's a question from Kat. I don't know if you can.
I could probably speak. Sorry. Yeah, it's two persons. One is studying in Italy. The other one is living in the UK with the pre-settled status. And the student in Italy, so they're in a relationship since 2017, and the student has seen her pre-settled status refused on the ground that she didn't reside. How can they prove their relationship, and can she apply for as a joint family member?
I think she
carry on, Hannah. Sorry.
I was just going to say, so she can definitely try to apply. So obviously there's like this general provision that that durable partners would have been living together in a relationship akin to marriage for 2 years, but that isn't a strict requirement under EU law. So you can argue that you have other evidence of a relationship, and that it constitutes a durable relationship. So evidence of anything that shows that they've been together, so correspondence or any joint financial ventures that they have, any time that they have spent living together, flight tickets which show that they've visited each other, that kind of thing. It's not guaranteed to work, I would say, but I think it's worth trying to apply as a durable partner, and just arguing that these provisions which say you have to live in a relationship akin to marriage for 2 years aren't a strict requirement, and that the evidence you can apply, there's no exhausted list of evidence you can apply to prove a durable partnership. Ellie, I don't know if you want to.
Yeah, no, I think I would agree with you, and I think it would probably be worth putting in a cover letter with their application, kind of making arguments along the lines that Hannah's made. So saying that they ought to be able to provide other evidence of being in a durable partnership. And for example, even though they haven't lived together for 2 years, they've been in a relationship for 4 years. And if they can evidence the duration of that relationship in the ways that Hannah suggested, then that is a basis of saying that that relationship is durable, even though they haven't lived together. So yeah, I would definitely suggest making an application on that basis. I mean, sorry, I wasn't clear about whether they've ever lived together just outside the UK, or whether they've never cohabited.
I don't know that.
Because they don't need to have lived together in the UK. So if they could show that they'd cohabited for 2 years in another country and could provide evidence of that, then that should be sufficient. So long as they can also show that their relationship has continued since then.
Yeah, okay, thank you.
Does anyone have any further questions? If not, then Emma, I would just say, please do keep in touch and let us know how you go on if you are making any arguments about the relevant document. It'd be really interesting to hear if you succeed in any of those.
Yeah, definitely. And we can keep you updated as well if we.
Yes, please. That would be really helpful, and I certainly will. Yeah, no problem.
Okay, great.
Thank you.
Thanks everyone.
Thank you, everybody. Thank you for coming.